Thanks, Nicole. And questions as we go is fine. I'm okay with that. We can manage it. I do do this a little law school fashion, and I do ask some questions. It's a little different. It's obviously easier and when we're all face to face to ask questions and get some nice dialogue back and forth. But at a minimum, I hope the questions help stimulate some thinking for you about what your potential liability is in permitting and planning and what your obligations are as a planner. So today we're going to talk about what are potential liabilities for conservation district planner and your planning activities. And these activities can range from advice given by a planner to a landowner's reliance on that advice to develop a plan, to the planner's conduct with a landowner. We'll also touch upon the conservation district liability as an employer of the planner. And then to bring it up to current, I'll talk a little bit about COVID-19 and potential liability issues around COVID-19. So what are we talking about when we talk about liability and what liability you might have? Generally, liability describes obligations, and the breach of that obligation may cause someone else harm. And it comes from what's called common law, which are court decisions, or it can be, the obligation can be a statutory obligation. It's based on there are obligations to do certain things, and there are also obligations to not do certain things. This liability is based on the relationship you have between the parties. So obviously in a landowner relationship, the landowner is looking to you as a planner for a certain level of reliability and a certain level of trust, which may establish a form of obligation that you have as a planner to the landowner. But what's interesting is the type of work that we do. Does it matter if the work that you're doing with the landowner and the recommendations are for voluntary practices? The landowner doesn't have to follow them. That could impact some liability in the sense that the landowner didn't have to follow the bad advice, let's just say. I'm not saying you all give bad advice. I'm just saying if there was some liability and the landowner said, oh, I got bad advice. Well, they didn't have to follow that advice because it's their voluntary practices. But what if the landowner does follow a planner's recommendation and later gets a penalty? Is there liability for the planner for making that recommendation that the landowner followed? And the answer to that question, as we were taught in law school, the answer to any question like that is it depends. So let's walk through what some of the potential liabilities could be to see if we could answer some of those questions. Generally, you have an obligation to a landowner when you're developing a plan. You have obligations to landowner if you're assisting in the installation of a practice. There's obviously more obligations when the district installs the practice itself for the landowner. There's also engineering liability, but they have engineering certification, but there could be design liability for the design of a particular project. So those are some of the different liability obligations. What are some forms of liability and how do these come up? Well, liability is really based on negligence, which means that you owe a duty of care to another person. And then there's a breach of that duty of care, and that breach directly caused an injury or a harm to the person or property, and damage was suffered. Now, in our context, the injury could be, it resulted in a penalty, say, from ecology. It could be an injury to a neighboring property, could be the result of the breach. It's based on a reasonable person standard, the level of duty of care and whether or not there was a breach is in part based on a reasonable person. But in case of professionals, such as planners, it's based on a standard of others in the same profession. Would other planners that had the same level of experience and certification, for example, would they have done the same actions? Some questions to consider, though, are does a planner have a duty to the landowner? Does a district have a duty to the landowner? Can a district refuse to provide assistance to a landowner if a landowner requests it? And is the duty of the district and planner different if the landowner is under a notice to correct? So the first, does the planner have a duty to the landowner? I think we'll see that if you engage with a landowner and the landowner is working with you on designing best management practices and addressing various resource concerns on your property, you do have a duty of care to the landowner to provide information, up-to-date information that's within your knowledge and skills, that's true and accurate to the best of your ability, and we'll walk through a little bit of that. So you do have a level of duty as you're engaging with the landowner. Does the district have a duty? Well, I think one could argue, in a sense, the district has a duty to make sure that the technical assistance that's being provided is the best, that's certified if possible, but is providing a level of information and engagement with the landowner that would meet the expectations for the landowner. There's also different duties the district may have with the landowner in terms of the conduct of the staff member that's going to engage with the landowner and how they conduct themselves and so forth. Can a district refuse to provide assistance? I think yes, it's a voluntary system, unless there's some other statutory obligation, which I'm not aware of. Say there might be, for example, the dairy world would be the one world where there might be some obligations, but otherwise, a district can refuse, and there are cases where the district has broken off assistance to landowners where the landowner has refused to follow the advice given to the landowner. Is there a duty if the district and plan are different if the landowner is under a notice to correct? So they get a letter from ecology and they have to correct, the landowner comes to the district. Does the district have a duty to respond? I think the answer to that one is the same as the previous, which is it's still the requirement of the landowner. So they can reach out and get assistance from the district, but it's still up to the landowner. And so there's not necessarily a duty for the district to respond. So other types of liability that may occur in these settings, one is called negligence per se, which is a legal term that means there's been a violation of a statute, and the act has caused the kind of harm the statute was designed to prevent. So for example, let's say the planner gives assurance to a landowner that it's okay to dump the contents of a 50-gallon drum, which looks kind of shady and oily and icky, and the planner says, yeah, you can go ahead and dump it in the stream, which would be a clear violation of several state statutes. That would be considered negligence per se. Again, not saying anybody would do that, but just trying to pick a hypothetical to make the point. Another that could trip you up is negligent misrepresentation. And this occurs when you misstate or misrepresent information while having no reasonable basis to believe it to be true. It could be a scenario that might be called the fake it scenario. You're trying to fake your way through something that you're not quite sure about, so you try to fake your way through. You could be giving misstatements or misrepresentations, not believing it to be true. The effect of the misrepresentation induces the other party into a contract. So then an example would be statements to try to get a landowner to enter into a contract for installation of a project. The landowner being told if they did so, there would be no enforcement. And later there is enforcement and impact to the resources. The question would be then, does the landowner have the ability to go back, if there are a penalty issued against them, to go back onto the district and say, I was given assurances that if I did this, there would be no penalty. Now, an innocent misrepresentation occurs when you believe that information is true, and that innocent misrepresentation is a defense to a claim that you misrepresented something. So if the claim is that a planner misrepresented that if you put in this particular BMP, you would not be penalized, and the landowner ended up being penalized, and the landowner came back at the district, you could defend saying, here's the information that I had that made me believe that information was correct. So it would be an innocent misrepresentation. Even though the information is wrong, you had reason to believe that it was correct. Intentional acts, these are obvious, overt, with intent to cause harm to a person or property. An example where this, again, not saying anybody would do it, but an act where this could happen is where one person engages in conduct interfere with another person's use and enjoyment of their property. I think an example of this one would be, let's say you're a planner working with a landowner on some fencing, and you know that the landowner is having a dispute with a neighbor on a boundary line, and you say, let's go ahead and put the fence across the line so you can assert your property interest on the other property. That would be an overt act with the intent of causing some harm to the other person, i.e. asserting a property interest over the other. So that would be an intentional act that could cause harm. There's also contract liability. Duties under contract liability come from the document that both sides have agreed to be bound by to do some act, and the breach of the duties within the contract give rise to liability. Now, some of this can come about in a variety of ways. Here's just one example. Regulatory agency meets with the landowner and says a fence must be constructed, but and if they do, there's no penalty if the fence is constructed. The landowner contracts with the conservation district for construction of the fence. Fence is not constructed. Agency moves to bring action against the landowner. Who's liable in this case? Well, again, that old great attorney response, well, it depends. It depends on what the breach was that brought rise to the fence not being constructed, and which party failed to follow through on their duties. And so if the district, for example, didn't follow through on their duties, the district could be liable under the contract for failure to construct the fence. On the other hand, it could be the landowner that didn't follow through. But that's an example of how a contractual liability can come into play. Another tricky scenario that we've had in the past is landowner contracts with the district for installation of a fence. They install the fence, but the landowner is leasing the property, and the lessor did not want a fence to be constructed. And then ecology said the fence needs to stay, but the underlying landowner wants to remove the fence. And so who's liable for what? Sounds like a bar exam question. But who's liable for what in that scenario? I would think generally, well, one, it's always good to check on those types of contracts, the contracting party, what their ownership interest is, just to be clear as a district that they have the authority to be able to construct on the property. But generally the liability would be on the lessee who made the obligations in contravention with the lease that they had with the lessor. It would really be between them. Negligent construction is an interesting one. Nicole and others that are familiar with this one. It's where there's a breach of duty or standard of care in the construction of a project, and the breach led to inadequately constructed project. The project failure leads to damages to landowner or neighboring or downstream property. Who's liable? The reason I say Nicole, I know up at Whatcom they've had issues with riparian restoration projects that are constructed not to breach a duty standard of care necessarily, but that the project led to flooding and impacts on neighboring properties. So what's been common, increasingly common in some areas, example is the construction of a riparian restoration site which attracts beaver. And beaver activity, they remove the recently planted trees at the restoration and construction of a beaver dam nearby. The beaver dam causes flooding of nearby landowner property. Who's liable here? It's a very interesting question. Part of this goes to the design and construction of the restoration project, whether or not the project attracting beaver and the consequent construction could be considered to be reasonable or reasonably anticipated that this activity would occur. It may happen with other kinds of restoration projects. There are cases where restoration projects where they do the installation of trees, for example, and the trees aren't adequately secured and you have a flood event. Trees break loose, go downstream and cause property damage. that's where that engineering liability could come in, whether or not the project was designed and constructed to be able to anticipate that situation. Generally under Washington law, actions by one landowner on their property that creates flooding that floods onto neighboring property can either be a cause of action for nuisance or even trespass. So there could be some legal claims here. So I think it's reasonable just to anticipate some of these. And I think that Brian Cochran in our office with the CREP program, we have some good guidance on how you can anticipate the presence of beaver or do some beaver dissuasion techniques that are out there and popular. So some district board and staff liabilities and duties. Board members have a duty of care to the entity in which they serve. And some board duties arise through statutory obligations and others through what's called a fiduciary duty, a legal standard to the organization. All board members have a fiduciary duty to the boards in which they serve. Staff members will have certain obligations as employees of the district, obligations to the district itself as an entity. Violation of commission or district policies could create liability. For example, a policy on cost share with board members and staff. If that's violated, there could be some liability that stems from that. And there's also appearance of fairness for board members, which I'll touch on in a little bit. Some areas of risk for conservation districts, and this isn't an exhaustive list. There's lots of attorneys and we're all creative, so we can make a long list. But there's obviously financial risks. There's risks around contract and grant agreements, contracts with landowners, conduct of district staff during visits. District boards, districts themselves are responsible for the conduct of different district staff out in the field. There could be liability around volunteers, and it's really important to have liability waivers and other documents when you're working with volunteers. And also remember, if you have staff that are working with volunteers who are kids, particularly under 18, it's important to make sure those staff have background checks through the state patrol. And then farm plans, as we talked about, there could be liability associated with the farm plans. What are some defenses? What if a landowner or somebody comes to you and you get a note, a friendly letter from their attorney raising all sorts of problems? What are some of your defenses? Well, one example of a defense is from the NRCS Range and Pasture Handbook, which is kind of interesting. Basically, it says, if an employee is acting in accordance with all federal, state, and local laws, and you're within the scope of your work, and you're doing your work in the scope of your work, there is no greater or less liability than that associated with performance of any other duty. Approval authority granted to the employee defines your scope of work. So basically, one defense is I'm working within my scope of work, and my work is being done consistent with federal, state, local laws, and I'm working within the scope, the scope of my district policies. That could be a defense from claims of a breach of a duty or liability. So compliance with district policies is really important. Make sure you know and understand your district policies and comply with those. Compliance with training for planners, take as much training as you can, because again, part of your defense, the better you have the knowledge, obviously you avoid any negligence problems, but also by having that knowledge and understanding, you're more likely to avoid problems, and you can rely on that defense saying, I was doing what is expected of me. And then under that, you're acting at the direction of district leadership. Again, doing as directed. Stay up to date on all applicable laws and planning requirements. Laws can change, obligations can change. And so we just want to make sure we stay up to date on those, and that will be a defense to help as well. So here's a real interesting scenario, liability for disclosure. So disclosure of information, generally landowner plans are not disclosable under state law and under federal law where federal funds are used. Such plans are exempt from public records requests, except when plans are developed consistent with a permit or can be disclosed by consent of the landowner. Now, disclosure could be unanticipated or inadvertent. And an example of this could be if you're at a public meeting and at the meeting you inadvertently identify a landowner who installed a practice and are describing the practice in detail. So you're talking about a practice that the landowner is installing, and that is a disclosure of information, particularly in some communities where everybody knows who you're talking about. So that could be a problem. But here's a challenge. How do you describe for a regulatory entity that the landowner has taken action under a plan when the plan is not disclosable? For example, where a county critical area ordinance allows the landowner to work with the district and develop a plan to address protection of a critical area, how will the county know if it can't see the plan? Similarly with voluntary stewardship plans, how do you know we're making progress if you can't share it with the farm plan with the county? Well, one way around this is a district can have an agreement with the county entity that's responsible, say the planning office that does the critical area ordinance, et cetera, that could describe that in the particular area that it can be described that actions have been taken, but you don't have to go into detail as to those actions, so that as long as the landowner is following the recommendations of the district, then there's no penalty under a critical area ordinance, and that those kinds of actions can be described generally or even in a range to the county. Another way to do it is to work out an agreement with the county where that information can be shared, but the county agrees to not disclose. So they can see the information, but then they become subject to the non-disclosure. Might be another way to go. But the other is, remember, you can always disclose a plan, a landowner plan, if the landowner consents. And in some of these scenarios with some counties, under their critical area ordinance, the county has approached the landowner because of a violation or a notice of some sort, and so it's in the landowner's interest to disclose what work has been done. But the trick is that you have to be careful about the scenario in which not to disclose. And the place where that could be a trap for the unwary is many of you participate in local processes, watershed groups, salmon restoration groups, and people get talking about a particular area, and conversation may be, hey, in this area we see that there's an increase in nutrient input into the water. It's got to be coming from Farmer Jones's place. And you blurt out, well, that can't be true. I've just been working with Farmer Jones and he's installing these practices. That's a disclosure, but it's an inadvertent disclosure. So let's shift gears now. Talk briefly about liability in the age of COVID-19. It creates new potential liability for the planner in the district because it's a highly communicable disease transmitted between people through contact or close contact. We really recommend that conservation districts should have a plan for staff engagement with landowners and follow social distancing, wearing of personal protection. That will help with any concerns about liability, but it also, frankly, is just good civil service to protect staff and to protect your constituents. Many of you already have plans in place, if not all, but if you don't, strongly encourage districts to have a plan in place about how you'll do landowner, and you should be very rigorous in following those protection standards.
Ron, do you mind if
Yeah.
I interrupt really quickly? There was just a question, I think it was right before COVID when you were discussing.
Sure.
The question asked, does the disclosure liability apply if there's no farm plan, just a landowner agreement to install a practice?
No, it does not apply because you're just talking about it with the landowner, and they're thinking about doing a project. So you don't, it doesn't fall within the limitation if there is no actual plan yet.
Okay, thank you.
I think again in that scenario, just try to remember to use caution and try to describe generally. You can even put it in terms of, well, the landowner is considering doing this or considering doing that. We may touch on it if we have time towards the end. I may touch on it again. So follow the protection guidance adopted by the district. So issue, a hypothetical landowner is visited by a district employee to plan a project. A few days later, the landowner feels ill and is diagnosed with COVID-19. Is the district and or the employee liable for that? Now, the challenge will be for the landowner to prove that it was the staff member who transmitted the disease. And that could be very difficult to prove, unless, of course, you're working in a remote area and you're the only person that the landowner has seen in a week-long period. But still, it'd be very difficult to prove. Plus, we'd have to prove that the staff member actually had it. Now, of course, COVID has all kinds of twists and turns, as we know. And even though a staff member is not showing symptoms, there is some evidence and conversation that it could be transmitted from asymptomatic individuals. So that just complicates it. But again, the real challenge will be for the landowner to prove that it was the staff member that actually transmitted. And generally, the protection for that will be if you're following district guidance, including using personal protection. It's going to reduce your potential for liability, and hopefully, our ultimate goal is to reduce the potential for exposure in the first place. Is there liability for a conservation district if the district is requiring staff to meet in person and the district has not adopted guidance? I would, and a staff member subsequently tests positive. I think there's a potential in that kind of a scenario for a breach of duty by the district. It just puts the district in a really bad place if the district doesn't have any guidance and yet is telling staff, get out there and work with landowners. Don't worry about a mask, don't worry about social distancing and that sort of thing. I think that's just really dangerous ground for a district. So adopting some guidance protects not only staff, but also the district. But it also, again, protects members of the public. So just make sure your district has guidance on these activities. I want to touch a little bit on planner ethics. I talked about this a little bit earlier. These are statutory obligations. All employees, public employees, must follow the statutes relating to abuse of office, will apply misconduct of public officers and code of ethics for municipal officers. All of these apply particularly to board members. So it's good just to be aware of these statutes. And again, just your conduct as a public employee, there are certain expectations around your conduct and your engagement with others. I had mentioned earlier appearance of fairness. Appearance of fairness is a common law doctrine. As I noted earlier, common law is court decisions created this doctrine. This one strictly relates to public hearings, but I think it applies generally too. But when the law, which calls for public hearings, gives the public not only the right to attend, but the right to be heard, the hearing must not only be fair, but appear to be fair. It's a situation where appearances are quite as important as substance. So that's the key phrase there, that the appearance of the conduct is as important as the substance. And the test is would a disinterested person, having been apprised of the totality of a board member's personal interest, the hypothetical is a board member has a personal interest in a subject matter that's being discussed and act upon, would the disinterested person be reasonably justified in thinking that partiality may exist? If yes, then you should avoid engaging in that course of conduct. So, for example, if you had a board member who is actually owns a company that, say, installs fencing, and they're approving projects for fencing that company would be used, that's really breaches the appearance of fairness. But does it apply to planners? Can you think of situations in which planners take actions or make decisions based on appearance of fairness may come into play. Again, it's when a disinterested person, external, looks at the conduct and wants to make sure that the decision you're making, whether to assist this landowner versus that landowner, that decision is being made fairly and not based on any other unfair. Some guidance from NRCS might be helpful here. In their procedures handbook, it says the success of conservation planning and implementation depends on the voluntary participation of clients. While participation is voluntary, personnel must carry out outreach to reach underserved customers such as minority and small producers with limited resources to ensure that services are offered to them on an equal basis with traditional customers. It's imperative that all customers are be treated fairly, equitably, with dignity and respect. I think it's interesting to note the distinction there when they talk about small producers and the admonition to make sure that the technical assistance that's provided to small producers and maybe even newer producers is the same degree of technical assistance and opportunity that's provided to new producers, even if they're a little larger producers or others. So it's being fair to all and being equitable to all is really kind of the underscoring there. So some discussion questions to think about here. If a planner makes a recommendation and it's not followed, who's responsible? So you go to the landowner and the landowner has a terrible condition on the property, and so you make some recommendations to improve the property, and the landowner says, thank you, but I'm not going to follow these. And then later, let's say the ecology inspector comes by and or a county staff finds violations and penalizes, who's liable in that situation? Well, I think obviously the landowner is obviously ultimately liable, and it's up to the landowner in the voluntary setting whether or not to follow the recommendations. But does it matter if the plan is voluntary or mandatory? Let's say in a dairy plan scenario where the plan is a mandatory plan and they follow the plan, but it's not, recommendations are not followed, who's liable there? Again, a lot of this liability will fall on the landowner for deciding how and what to implement in the plan. Where your planner liability falls in is what are the recommendations that you're making? Are you making the appropriate recommendations so that if the landowner does rely on your recommendations, where does liability fall? Is there increased liability if you're certified? Remember, one of the criteria is sort of, is the recommendation the same as someone similarly situated? So it's not so much another planner, but another planner, if you're certified, is it the kind of recommendation that another planner certified similarly would make the same recommendation? But if, is there increased liability if you're certified? In a way, yes, simply because you have a higher standard of expectation of being, understanding the law, understanding how plans are written, and so forth. And so a defense of, gee, I just didn't know, if you're certified, won't play out. So the best way to avoid or minimize liability exposure is just to be upfront, open, honest with the landowner and producer as you're talking to them to the extent of your knowledge. It's always okay if an issue comes up for you to say, I don't know, I'll check with somebody who does. The worst scenario is to fake it and get relied upon, and then some damage occurs. We had this question in the past. I just kept it in case it still lingers out there. Enforcement is lacking in some areas. How do we do adaptive management to make sure things get done if there's no enforcement? How do we work with regulatory agencies to enforce? Feels like we're wasting time on plans is a comment that was made previously. And yeah, it can sometimes feel that way because enforcement is not our bailiwick. Best we can do, I believe, is one, work with landowners in such a way that if they implement the recommendations, the BMPs that you recommend, the likelihood of enforcement against them is diminished. You can never guarantee that there would be no enforcement, nor should you guarantee there would be no enforcement. You should never say, if you put up this fence, I guarantee you there will never be enforcement. Or ecology will never come around and take a look. Or if a landowner says, if I put up this fence, is it guaranteed that they won't come around and look? And I think your answer is, I can't guarantee that ecology won't come around and look, but I can say that I'm confident that you're addressing the resource concerns and there won't be much to be found to raise concerns. And that's really the best that you could do in that scenario. And then the other is for your district leadership to work with local regulatory agency staff if lack of enforcement is a problem. I know there's several areas there have conversations about enforcement and how to improve that type of enforcement and outreach. Because enforcement, even though not in our bailiwick, enforcement is something that does help our work, in the sense that if landowners see regulatory agencies are serious, then the landowners will want to come and work with a district on what voluntary activities could be made. So to summarize, generally liability stems from obligation from one individual or entity to another. The breach of the obligation causes damage. Obligation can be to do an act, but also to not do an act. Landowner reliance on planner assurance can create liability, and general defense to liability is if the planner is following policies. Also, the voluntary nature of landowner obligations create a defense in the sense that landowners voluntarily adopt the recommendations. So I ended with a lot of time. I do have a little bit more if we need to. If there aren't a lot of questions, I could touch on some hypotheticals. But Nicole, I don't know if we have questions or comments.
Yeah, so I'll just remind folks at this point, please put in questions into the question box, and or if you raise your hand, I can unmute you and you can just ask direct. There's one question in here, and it asks, can a planner recommend a member of their family that's a contractor for a landowner project?
That is really shaky ground and gets to the appearance of fairness of recommending your own family member. I would not do it. I know it's hard in smaller communities not to do it. It's better to have a list. If your family member is on a list, that helps somewhat. But I would strongly recommend not doing that in case there are any problems.
Okay, another question we got here. What would the standard answer be to a county or regulator or someone who calls to ask if the district is working with a landowner, or does the district have a plan, even if you don't give details, but they want a yes or no answer?
It's appropriate to say that you're working with the landowner, and whether or not you know that the landowner has a plan. But again, you can't see the plan. Knowledge of the plan is okay. They just can't see the details of the plan unless the landowner consents.
Okay, I think this one's a little bit of a follow-up to the question earlier about the disclosure if no farm plan. So this question is an executed landowner agreement to implement a project in effect a, quote, plan subject to non-disclosure?
I don't believe so, because I have to look, and there's going to be RMs will be having a brief on this subject that'll be coming out soon. The term farm plan is a specific statutorily defined item. And what you described, in my mind, does not fit the statutory definition of a farm plan.
Great. You said that laws change and that we need to stay current. What resources are there for staying current on the evolution of laws affecting conservation district actions?
Part through the Conservation Commission, as we do our legislative work, we always try to do outreach to make sure everybody's aware of what's happening in terms of any changes in the law. The other is WACD. They're very helpful in that regard as well. I think one of the areas that in the law and how it's applied that changes that can be particularly challenging is agency interpretation of laws and how they want to apply those. We've had issue in the past, say, for example, we know that the statute, water quality statute, says you cannot cause a discharge into the waters of the state, which gives ecology regulatory authority to require fencing. the debate becomes fencing at what distance from the stream. And so there have been issues in the past where ecology may say a fence at a certain width is okay, but then they may change because there's interest among the tribal community and others to say we need wider buffers in order to achieve our riparian protection goals. So knowing what those are as they're adopted is one challenge. The other question that then comes up is a challenge that happens at the local level where a planner may say we can achieve the same no discharge objective with a fence at a distance less than what ecology would like to see. And we get into some real debates around that. And that gets really sticky really quick. But and it's hard always to know where that is, but generally if you keep tabs, and we're trying to keep making sure districts are informed about these kinds of changes when they happen. One of the nice things is that in environmental law, changes don't happen, dramatic changes don't always happen overnight. They're more gradual. There's a lot of conversation, and so everybody knows about the changes and what they are. It's just understanding how they impact us. The current Trump administration changes to the definitions of what are considered waters of the state as an example of, is it on again, off again, what is it? But then also, what does that impact to the state, water quality or water planning, and then how does that impact planners? Those are some of the questions that we have to sort through.
Thank you. And Joe was kind enough to provide a sentence about the farm plan disclosure. I'll just read, and then we've got another question here. So it says the farm plan disclosure sentence from RCW 8908-560 is the farm plan shall not be disclosed by the conservation district until the requesting owner or operator confirms the information in the farm plan and a signed copy of the farm plan is received by the conservation district. So that might help as well with that definition.
Remember, you don't have to disclose something if it's not in your possession.
Good to know. A question here. Shoreline stabilization projects are very expensive for landowners, even with cost share. How do you suggest responding to other landowners who are frustrated with neighbors who stabilize their properties with treatments that are not permitted by regulatory agencies, yet the neighbors don't suffer any enforcement penalty?
That's an interesting question. Could you read that again?
You bet. Shoreline stabilization projects are very expensive for landowners, even with cost share. How do you suggest responding to landowners who are frustrated with neighbors who stabilize their properties with treatments that are not permitted by regulatory agencies, yet the neighbors don't suffer any enforcement penalty?
Yeah, we've seen that in other cases. I remember one in Skagit where the landowner had put in a lot of fencing and protection, and when asked by folks on a tour whether he was happy, he said, no, my neighbor upstream isn't doing anything and nobody's enforcing. I think, but it's also an interesting question, what's the role of the district in terms of going to a regulatory agency and saying, hey, in this scenario, nobody's enforcing. I kind of leave that to the district manager to decide the politics of doing that. I know landowners don't really like conservation districts in a role of saying, hey, they're not doing anything, go enforce. I know they're split on that. And so I think what you do is continue to work with the frustrated landowner to say, okay, locals may be aware of that, but the best we can do is work with what we have here in front of us. Let's control what we can control and continue to do the shoreline stabilization the way we're doing now, but then maybe address the other illegal activities in a different context. It's really delicate ground to be on. We have this, when we first started this liability conversation, we also had a component about talking about ethics. And I had a scenario that happened with a district that'll remain nameless. And I was on a tour with the district, and we were driving around and visiting some sites. I was in a car with 3 other district staff, and they wanted to point out a specific farm to me, a farmer that was particularly difficult to work with. And as we were driving around the curvy road, we come around a corner, and they were debating, is it this farmhouse or is it that farmhouse? And I said, well, maybe it's the farmhouse with the dead cow in the front yard. And there was an actual dead cow, 4 legs up in the air, and there were actually some crow pecking at the cow. But it raised an interesting question. Should anybody in that car have picked up the phone and called public health or anybody else about the dead cow in the front yard? And it was interesting later, meeting with district staff, I said, hey, here's what happened. And I walked through it with everybody. And I said, what do you think? Raise your hand if you think you should call somebody. And it was 50-50. 50% said, yeah, we should. 50% said, no, that's not our role. And then later I was meeting with the district board and shared the story with the district board and asked for a show of hands whether or not. And again, it was split down the middle. There were some saying, yeah, it's our duty in our role in natural resources to be able to make that call. And others saying, no, we're playing the role of a narc, if you will, and calling somebody in and filing a complaint, and that's not what we do. So I just thought that was kind of interesting. And I see the application here about, okay, if you see an illegally installed structure and a landowner neighbor's complaining to you about it, what do you do? Maybe talk to your manager and think through. There are soft approaches that you could use to approach the county in doing that. I had another hypothetical on disclosure where, let's say you're at a meeting and they're talking about restoration of a particular stream reach. And in that, you get all excited in the course of the conversation and say, oh yeah, I've been working with this landowner and they just won't do anything. And I'm trying to get them to put up a fence and they just refuse. And they've got all kinds of problems and they refuse. Is that a breach? Did you violate some duty of, the landowner brought you to the property and so forth? You have a breach. Did you breach a confidence or a liability there? And then extend that further. Let's say the next day, ecology staff that were at that meeting pay a visit to the landowner and see what's going on and issue a notice of penalty to the landowner. And then the landowner finds out that it was you at the meeting that brought it to their attention. Are you at risk of some liability there? Interesting questions. I know at one of our sessions were in the past where we talked about this, one district supervisor said, Ron, I don't know if there's any liability for making those comments, but it sure was dumb. So just kind of be careful in those kinds of settings with others.
A follow-up to that, Ron, question, it says, in relation to the dead cow incident, what about reporting cases of animal abuse or neglect?
Yep.
It says, I would do this, but is there liability in doing so given our non-regulatory obligation?
Yeah, that's a good question. And there's also, that becomes an ethical one. Ethically, do you have an obligation when you see that kind of harm to report it? I think my view would be yes. It's okay to report it. But it also raises the question, what do you do if you see illegal activities occurring on a property? And depending on the activity, sometimes you can provide friendly advice to the landowner to make a correction. Hey, this could be a problem. You might want to do this. That kind of, I'm not going to report you, but this kind of thing. But when it comes to animal health and the condition of an animal, it seems to me that there are some ethical considerations that come into play. And just my own personal view is I don't think you should have any qualms about saying this needs to be corrected.
Okay, thank you. Another question here. If we don't have to disclose something that is not in our possession, how do we prove that we do not have that record? If this were to go to litigation, how would you prove in court that this record didn't exist? At times, landowners have engaged in litigation on items like this to draw out court proceedings and rack up legal fees in hopes the CD will settle to avoid continued cost. Is there a way to avoid this scenario?
I'm resisting the joke of, as an attorney, I don't oppose racking up legal fees, but I think that, yeah, it's asking how do you prove a negative, but if you don't have it, you don't have it. And this is true in any public records request disclosure. The key is that you do a search, that you can demonstrate that you have done an extensive search for the document, and in that search, you didn't turn up the document. Now, where you get in trouble is if a coworker says, well, I got it, or I gave it to you. But if you don't have it, you don't have it. And it could even be a scenario where if you're supposed to have it, but we look through our records, we just don't know, we don't have it. If you don't have it, you don't have it. And that's all you can go by.
Great, thank you, Ron. Folks, again, just a reminder, any other questions, put it in. A follow-up to that one, Ron, if they have a physical copy, but what about electronic copies?
At the district? I assume it's at the district. If electronic copies have to be disclosed. And that's a new thing in this disclosure, is making sure, that's what I was meaning about the search. You really have to do a thorough search, and it's not just physical records, it's all electronic records, it's all emails, it's including text messages, documents you might have on a phone or a pad. And then Laura Johnson's been working with folks at our shop, has been working with folks in communications about things posted on social media is another area. It even goes further, that when you're searching records, to make sure that your board members, their records need to be searched, which could include if they have their personal laptops that they use for their board activities, those may have to be searched. So it's really important to have a really good district plan for how you're going to store and retain records, and how you file records, how long you'll hold those records, and to follow those storage and retention policies. That will help a great deal. And again, we have had public records requests. There's one in San Juan where the requester wanted every document ever created by the conservation district since its inception. And it's okay to say, we trash records that are older than 7 years. That's our retention policy. That's okay.
Great, thank you. And so I think this one relates exactly what you just said. This question is, what about our IT company who archives records? Does that 7-year time frame still apply?
Yep. Yes, it does. And also their records have to be searched. If you have a contract with an IT company and they're retaining records for you, you have to make sure that you search those records. Failure to do so, because technically it's still in your possession, it's just you have a contract with somebody, failure to do so could lead to penalties in court. So you want to make sure that if you have a contract with somebody that's retaining records, that those are searched.
Thank you, Ron. And then a question, I don't know if you touched on it in the permitting realm of things. I know NRCS's policy is they do not help people with permits, period, but I know a lot of district folks do. What is the liability of a district planner assisting someone with a permit if something goes awry with that project?
Yeah, I think NRCS is the federal policy. Again, with the permit, it goes to a lot of the liability or negligence standards that I walked through. As long as you're working with that person in good faith, that you're working with them to the best of your knowledge, and presenting options and so forth, you can show that with that permit, options selected by the landowner or what the landowner chose, that you weren't negligent in terms of misleading, either deliberately or inadvertently. You're okay. You can assist the landowner, but that's where you also need to understand the flip side, which is what is the regulatory agency looking for in that permit, and making sure that it's just good customer service to work with the landowner to try to achieve what the landowner wants to achieve, but at the same time, you're knowing what the regulatory agency is looking for and writing the permit in such a way that you're achieving that objective as well.
A quick follow-up with that, for that permitting process, you can assist, let's say, a landowner writing the permit, but in the end, does the landowner need to submit that permit, or can a district do it on their behalf?
I would recommend that the landowner submits the permit because that's where the obligation is with.
Great. An awesome question here to you, Ron, says, would you be up for a monthly or periodic Zoom chats like this with individual districts? This is really helpful and quick guidance.
Yeah, I'd love to. We actually have a longer presentation if you want it, where I go into different laws and so forth that are applicable. I'd be happy to set those up. All I would ask is I'm able to do that after I get my COVID haircut.
Fair enough. And I will note for everybody, Ron's information is up on the screen right now, and he's an incredible resource. And I have heard his longer presentations with the laws. I believe you did it at Wade a year or two
I did.
ago. Yeah, and it
Yeah.
was fantastic. Mm-hmm.
And then we can have some fun with other hypotheticals. There's different hypotheticals that I can come up with that we play with that help make you think, but do it in a fun way.
Yeah, and there's been some great suggestions about, doing this on a statewide basis, maybe part of that community call forum that Shauna has developed with the commission, that there's maybe this liability section on there. So
Sure.
that would be great.
Sure.
There's also comments that you look great. So haircut or
Thanks.
not.
Thanks.
And so in our final minute here, if there's any last questions, please raise your hand or put it in. Otherwise, Ron, if there's anything you want to add here at the end, you've got the last minute to do any more platform here.
Thanks everybody for participating today, and look forward to doing some Zoom chatting and other conversations, especially as the legislature and that world kind of picks up in special session and on to the next biennium.